Good morning. I am Nicola Phillipson and I am a barrister at Park Lane Plowden Chambers in Leeds. And I specialise in contentious probate and inheritance, and as well as being a barrister at Leeds, I have also written a book called, there you go, you can see it. If I'd done slides, I'd have done it, but this is my book, and the book is A Practical Guide to the Law in relation to control of the body after death, because that is also one of the areas in which I specialise. I do a lot of work dealing with bodies and ashes and the like. And it's on that basis that I was asked with Julia to talk for Phil Circle earlier in the year about disputes over bodies. And that talk is still available. It's on YouTube apparently, but you can get it through Full Circle's website. And the basic takeaway from that talk was that there is no right of ownership in a dead body. Nobody owns it, so nobody can say it's mine and therefore this is what must happen to it. That includes the dead person themselves. Their ownership of their own body ends with death. So even the wishes that they express in their will are not actually binding. So your will can say, for example, I would like to be buried in Brighton on a Friday in a pink coffin, but your executor can actually decide to cremate you in Wigan on a Tuesday. It's a matter for whoever it is who is dealing with your funeral and indeed dealing with your body. Because you don't, as I said, you don't have any ownership of your body. Nobody owns a body. But what does exist at common law is a duty to arrange for the proper disposal of the body. And the person who has that duty can call for the body and decide how to deal with it. So when dealing with disputes over how a body should be dealt with, so buried or cremated, buried in Brighton or Wigan, the argument isn't actually over who has the right to the body, it's over who has the duty to make arrangements for the body. And the usual hierarchy for all of that is that where there is a valid will, it is the executor or executors named in the will. Where you have an intestacy, so somebody who hasn't left a will, but there is somebody with letters of administration, so somebody who has been appointed as administrator, then it is the person who has those letters of administration. Where you have an intestacy, so nobody has a right as an executor, you have an intestacy, but nobody has been appointed administrator because they don't have any letters yet, then it will be the person who has the right to take out the letters and who has the highest right. For lawyers, that's section 46 of the Administration Estates Act 1925 and rule 22.1 of the non-contentious probate rules. For non-lawyers, it's essentially, you can look it up on the internet, just type in who has the right to letters of administration, and it will give you a list of who is the person who is entitled, its spouses, children, parents, that sort of thing. If you haven't got a will, you've got an intestacy, but you don't have anybody who wants to or who has taken out letters, then the next person down the hierarchy is the householder in whose property the deceased died, or the person with actual possession of the body. And I know that sounds a little bit weird, but if you think about the reality of that is going to be the hospital or the coroner normally, you can see that it makes sense. In the absence of any of the above, it's going to be the local authority. So those are the people who have the hierarchy. They're the people who can call for the body because they have the right to deal with it. Or rather, sorry, they have the duty to deal with it. And although the court can make an order appointing somebody else, and where you have an argument between two people or more than two people who are equally entitled, which I have to say is usually children or parents of the deceased, the court will determine who should have the final say. And that is basically a very quick run through of the talk which is still out there that you can still access, which is about bodies. And if you have a body, who can call for it. But I've given you that basic recap because I think it is helpful to have some context when looking at the subject of ashes. And of course, before you have ashes, you have to have a cremation. And the cremation itself should, in theory, be relatively straightforward. It's governed by statute. the Cremation Acts 1902 and 1952 and by associated regulations. And an application for a body to be cremated is made by way of prescribed forms. And that's either made by an executor or a near relative who is aged 16 or over. Now, a near relative is defined within the Acts themselves, and it is a widow or a widower or a surviving civil partner. It is a parent or a child or any other relative usually residing with the deceased. And they are the near relatives, and they have a right to make the application. But an application can also be made by other people. It can be made by somebody who isn't a near relative and who isn't executor, but that other person can only make that application if the medical referee is satisfied that that other person is a proper person to make the application, and is satisfied as well with the reason given by that other person as to why the application isn't being made by an executor or near relative. And the medical referee also has to be satisfied that the executors and near relatives have been informed of the application. So essentially, if you are not the executor and you are not a near relative, but you are the one who wants to organise the cremation, you can turn up and make the application, but you need to satisfy the medical referee that you are an appropriate person to make it, and also that everybody who has a right knows that you're making it. And an obvious example here is an application by a cohabitee of someone who's died intestate. So you are the long-term partner of the deceased. He has children from a first marriage. Everyone's happy that you're the one who's going to be dealing with the cremation. You're the one who's going to be dealing with the funeral as the long-term partner. But you're not actually someone who fits into the criteria of near relative or person entitled on intestacy. But you would be the obvious person I said to be another person. And I raised that before I deal with ashes because the identity of the person who fills in the forms is important. And it's important because the person who becomes the applicant for the purposes of the cremation, and you become the applicant by signing the forms, is the first person who has control of the ashes. And the reason for that is because after the cremation has taken place and the cremation authority have gathered up the ashes, they have an obligation to either dispose of the ashes in accordance with the applicant's instructions, or where there are no instructions or the ashes are not collected in accordance with those instructions, the cremation authority may dispose of those ashes by burying or scattering them. So we can see there that the person who signs the form is the person who can tell the cremation authority what to do with those ashes, and the cremation authority must dispose of the ashes in accordance with those instructions. So if the person who signs the forms says that the ashes must be released to Great Uncle Gordon rather than to the children of the deceased, then that is what the cremation authority must do. And if you are the child of the deceased and you want those ashes, but you didn't sign the forms, then your fight to get those ashes back or to have those ashes dealt with in accordance with your wishes is not going to be with the cremation authority. It's going to be with Great Uncle Gordon, because he's the one who's going to have the ashes released to him. So if you think that there is going to be a dispute over the ashes, the best advice I can give you at the outset is to make sure that you, or somebody who is on your side, so to speak, and acting in accordance with your wishes, is the person who signs the cremation forms. Because if the person who signs the cremation forms is on the other side, effectively doing something, and you know they're going to do something that you don't want them to do, you may want to think about resolving those differences before the body is cremated. Because experience tells me that once somebody has the ashes, it can be very difficult to get those ashes back or have them dealt with in accordance with your wishes rather than the wishes of the person who actually has them. And of course, one of the difficulties that we have with ashes is once they have been scattered, or once they have been buried not in an urn, but simply interred in the ground, it is impossible for them to be retrieved and they're gone. Assuming, however, that Great Uncle Gordon hasn't scattered the ashes, but has put them on the mantelpiece, and I say the mantelpiece because that is where all films and all novels seem to store ashes. Although I suspect the reality is somewhat different. I know when my grandparents died, my grandfather was kept for years in a box in the cupboard under the stairs because we were waiting for my grandmother to die so they could be scattered together. But we're going with mantelpiece because that seems to be, the cultural norm. So assuming that a great uncle Gordon hasn't scattered your ashes, but he's put them on the mantelpiece, and you then have two different family factions wanting to deal with the ashes, the question is, how is that particular argument going to be resolved? Now, I can say without hesitation that the best solution is for all the parties to sit down and reach a compromise. And if necessary, that compromise should be by way of mediation through somebody like Julia, or indeed Julia herself. And you're going to hear from Julia about dealing with these matters by way of mediation, by way of compromise. And the reason I recommend that route first is not because I'm trying to do myself out of some court work or anything like that, but it will be quicker and it will be cheaper, both in financial and emotional terms, because the only alternative to reaching a compromise will be a court hearing. And court hearings in this area are never cheap, and they are not known for bringing warring families and disputing parties closer together. But if you can't resolve your differences by agreement, and you do decide that you need to go down the court route, there is one curious feature of ashes which you will need to bear in mind. And that is that although a normal dead body cannot be owned, as we've already looked at, if that body has acquired different attributes through the application of skill, such as dissection or preservation, it becomes property and can be owned. So you have somebody who's died, their body is just a dead body, and as I said before, it can't be owned. It can't be owned by anybody. It's not property. It's then buried, and that's effectively the end of it. However, if that body is in fact dissected, or it is preserved, or there is some other application of skill or preservation technique applied to that body changes from not being something that can be owned to becoming property, and that body can then be owned. That is why if you were to steal a body part from an exhibit from a museum, or you were to steal anatomical specimens from a hospital, you can be convicted of theft, and you can't rely upon the defence that nobody owns the property as it cannot, nobody owns the body as it can't be property. And in a similar vein, ashes have been deemed to be property and therefore can be owned. Now, that seems a somewhat startling proposition because, of course, the general assumption is, well, nobody owns a body, therefore nobody owns ashes. And the starting point for this proposition is an Australian case of Leeburn and Derndorfer from 2004, where the Supreme Court of Victoria presided over a dispute between the three sibling executors over the ashes of their deceased father. Now, you've got three sibling executors. These are the children of the dispute, children of the deceased, so they all have an equal right to call for the body. They've all got an equal right to deal with the body as they wish. Their father was cremated. And presumably, knowing that there was a dispute in the offing, two of the siblings retrieved the ashes from the crematorium and caused them to be buried in a cemetery, but without informing the third sibling, who was the claimant in this case. 2 years later, the claimant commenced an action asking for the ashes to be disinterred and divided into 3 portions, with each sibling having a portion to do with as they wished. In dismissing the application by the claimant, the judge noted that there was a difference between a corpse and ashes. He noted that with a burial, the executors or the administrator, whoever's in charge, discharges their obligation by having the body buried. The body then becomes part of the land in which it is buried, and the executors have no further function to perform and no further interest in the remains. However, with ashes, the situation is different because an executor is not bound to bury the ashes. Of course, the body goes to the crematorium, the body is then cremated, and the executor gets the ashes back. There is something else the executor has to do because he has these ashes physically in his possession and needs to deal with them somehow, even if it is only to put them on the mantelpiece. So with ashes, an executor is not bound to bury them. They may be retained, they may be buried, they may be scattered, or they may be divided and the different portions disposed of differently. So he said ashes are very different from a body because you don't simply discharge your obligation by sending the body off to be cremated. And then what he said was, moreover, so long as they are not dispersed or otherwise lose their physical character as ashes, they may be owned or possessed. To my mind, therefore, it is apt to characterise the legal status of the ashes as similar to that of the preserved body in Dodewood and Spence, and that was a case where a preserved body was treated as property. He then went on to say, ashes which have in this way been preserved in specie are the subject of ordinary rights of property, subject to one possible qualification. In this way, ownership in the ashes may pass by sale or gift or otherwise. The only qualification which, if it exists, may require some working out, arises from the fact that the ashes are, after all, the remains of a human being, and for that reason, they should be treated with appropriate respect and reverence. So in a nutshell, what he was saying is that cremation turns a body that can't be owned into material which can be owned, in the same way that dissected and preserved bodies or body parts can be owned, as we've seen usually by museums, hospitals and science labs, but they can be owned. And if they can be owned, then they can be sold or they can be gifted, although remember the qualification at the end about the fact that these are remains of human being and appropriate respect and reverence. I do not think it will go down terribly well if somebody starts trying to say that actually I will give the ashes to the person who makes the highest bid. The judge then went on to consider the legal interest of the executors in the ashes. And he said that the ashes did not form part of the deceased's estate, and therefore they did not pass under the will. Because quite often under a will you say, well, I leave this to Julia, I leave that to Sarah, and I leave everything else to Nikki. In which case you could say, oh, well, actually, everything else, they're the ashes, they fall under the estate, I get the ashes. But the judge said, no, they don't form part of the estate, they don't pass under the will. Instead, he concluded that the executors hold the ashes as trustees, and they hold them as trustees for the purpose of disposing or dealing with them in a way that seems to them to be appropriate, having regard to any direction of the deceased in the will or otherwise, and having regard to the claims of the relatives or others with an interest. So essentially what he's saying is that they hold those ashes to deal with them appropriately, having regard to the wishes of all interested parties. So if, for example, in the will, the deceased has said, I would like the ashes to be scattered on top of a hill, that's something they also need to have regard to. If you've got 3 children, all of whom want to do something different with the ashes, again, that's something that they need to have regard to. And they hold them effectively as trustee. And the conclusion reached by the judge that the process of cremation as a result of turning the ashes into property has been followed in this country by District Judge Marin in a case of DP and JCP, and that is a case from 2010. Now, the facts of that particular case are not remotely important or even relevant because it's actually a court of protection case about a financial dispute over financial deputies. But one of the matters in dispute was, as well as arguing over the money and everything else, it was actually who had control of the ashes of the party's mother. And District Judge Marin followed the reasoning in Leeburn, and he said the ashes are held on trust by the person who physically has possession of them for the purposes of the family disposing of them. Now, interestingly, the idea that ashes were property and therefore can be held on trust had also been addressed 11 years earlier in this country in the case of Bessie and Whitmore from 1999. And in that case, there was an ashes dispute between 2 separated parents. Each parent wanted the ashes of their child buried in the cemetery nearest to them. You quite often in body and ashes dispute have the very difficult decision, or the court has a very difficult decision where parents have separated, a child has died, and both of those parents want the child or the child's remains to be buried closest to their home. And that's what happened in Bessie and Whitmore. And the court determined this matter not on the basis that it was being asked to give directions in administration of an estate, so not in relation to dealing with the body, not in relation to who has the right, but on the basis the court was being asked to resolve a dispute between two trustees. And as the parents couldn't agree on where the ashes should be buried, the court made the decision for them and gave directions. So we can see that even if you have one person who clearly has the duty to dispose of the body and therefore organises funeral and cremation, so you have a will, it appoints Sarah as the executor. Sarah then has the right to deal with it as she wishes, and she organises cremation. That in itself doesn't solve the issue of whether Great Uncle Gordon, who's got the ashes because Sarah signed the forms and said, please give them to Great Uncle Gordon, it doesn't solve the issue of whether Great Uncle Gordon should keep the ashes himself or give them to the children of the deceased. Because as the holder of the ashes, the gentleman who actually has the ashes physically in his possession, he is now a trustee. And instead of making whatever decision he likes, he needs to take all of the relevant circumstances, including the beneficiary's views, into account. The beneficiaries will be all of those people who have an interest in the ashes, which of course can be a large category of people. You don't just have the children of the deceased, you could have the children, you could have siblings, you could have aunts, uncles, people who were close to the deceased. And if a compromise between those various people can't be reached, then either Great Uncle Gordon or any of the beneficiaries can apply to the court to have that dispute resolved. And the way that that is done would be under Civil Procedure Rule 64. CPR 64 essentially says that trustees can apply to the court for the court to resolve any issue arising in the administration of a trust. This clearly will be an issue arising in the administration of a trust. So you would have the trustee or any of the beneficiaries. It doesn't have to be the trustee. Anyone can apply to the court and say, this is a situation. We have a trustee who's holding the ashes. We are in dispute as to what should happen to them. Please, will you make a decision? And that will follow contentious contentious court proceedings in the usual way. So the person who makes the application will have to file the application. They'll have to pay the issue fee. They will have to file their evidence, which sets out exactly what the dispute is. Those who dispute, or those who are involved in the dispute, will then have to be joined as parties. They will then have to file their witness statement evidence. There will then be a court hearing. People may order some disclosure. They will order witness statements. Other people will seem to get involved. And there'll be what's called the directions hearing. Things will be laid down for trial, and then there'll be a trial. And at that trial, witnesses will be called, evidence will be taken, there will be cross-examination, and then there will be a decision. And if you haven't guessed by now, all of that is going to cost quite a lot of money. It's contentious litigation in the usual manner. So the usual costs order will apply, which is that the losing party will generally pay the costs for everybody. And when you have trust disputes, what normally happens is there is normally money in the trust. So certainly the trustee is paid quite often by the trust, even if everybody else is paying their own legal fees. In this case, of course, unless the ashes form part of a bigger trust specifically, usually it's just a dispute over ashes. And whilst ashes may be obviously of enormous emotional significance to people, they are, intrinsically have no financial value. So there is no money in this trust. So if this matter is proceeding to court, all parties are going to be paying for this out of their own pocket. Now, one possible advantage that ashes have over a body, of course, is that ashes can be divided up and they can be given to different people. That's exactly, of course, what the claimant wanted in the Australian case. But you need to tread carefully here. I'm a very practical sort of lawyer, and I think it is an excellent solution when you have a dispute over ashes to give each party their own portion and let them deal with them as they wish. But not everybody is open to this idea. And I have had clients, I've had opponents who are appalled at the idea of separating what they consider to be the remains of their loved ones that they think should remain intact and whole. And that is a perfectly valid and understandable point of view. And when it was raised as a solution in the case of Fessy, and the mother opposed it, saying no, she didn't want the remains of her child to be divided into two portions, the judge in that case, Judge Boggess QC, rejected this course of action on the basis that it was wholly inappropriate. So certainly if you have the situation, you want to go to court and say, well, it's an obvious solution, we're just going to divide it between everybody who's got a dispute, that is not necessarily going to work. But it is an option to be explored. And clearly it's an option which may become more palatable when the parties realise that the only way out of this deadlock is very likely to embark upon very expensive trust litigation. And it's here now that I'm going to hand over to Julia, who can hopefully tell you how to avoid that very expensive trust litigation by dealing with this matter between parties by way of mediation or some other form of alternative dispute resolution.
Thank you, Nikki. I've certainly learned a lot myself listening to that, so thank you very much. It was very interesting and very, very clear. So yes, I am a mediator and a conflict coach, and I'm also a lawyer. I've been a lawyer for 17 years, 15 years of that time doing contentious trust and probate work. So in my time, I have seen my fair share of disputes about ashes. Thankfully, none of them has ever actually gone to court. I've always managed to settle them. I think settlement has always been in my blood. Now I'm a mediator doing that pretty much full time. So, yeah, I just want to say a few words about, obviously, Nikki said there's a different way of doing this, and there's a better way if it's possible to avoid court, and often that is mediation. Ashes disputes are very, very common, I think, in contentious probate situations. It does tend to come up often as an ancillary sort of situation where really the family are arguing about the money, but the ashes can often come up, and it's often an issue that is dealt with at mediation. It has to be handled very sensitively. These cases are particularly difficult. There is often a huge amount of acrimony involved, and often the parties can be very entrenched in their views, and certainly by the time by the time I see a case when it comes to mediation, sometimes it can have gone on for a very long time. And it's understandable. It's a very difficult emotional situation, and what makes it difficult is not normally the law. It's the emotion that the grieving parties are often carrying. Just to give you an example, and apologies, I know some of you were at the previous talk, and I did use both the stories that I have in that talk, so you're going to hear them again, but they are very good examples of how these things can play out. I once mediated a case which had been, by the time it came to mediation, had been going on for 5 years since the death of this individual. And the dispute was between a grieving mother and a grieving widow. The father had died rather suddenly. He had 2 children, one of whom had quite complex mental health needs. And it had become very, very complicated, in particular because the child with the mental health needs had become involved in this dispute emotionally and had developed a really quite strong attachment to his father's ashes. And that obviously was a feature that made the case extremely difficult for everybody to deal with. But actually what made the case really difficult was some of the dynamics that played out in the legal correspondence. And as I said, it's gone on for 5 years. One of the law firms involved had been proposing mediation for quite some time. The other law firm involved had just said no to it. And at one point, I read in the bundle in the correspondence, the line went along the lines of, I don't know why you think mediation will be successful. We've effectively been mediating this for the last 4 years. At which point I had my head in my hands just thinking, if you think what you've been doing in correspondence has been mediation, then, oh my goodness, I don't know where to start, because obviously litigious correspondence, adversarial correspondence is so far away from what a mediator does and what happens at mediation. But anyway, it did finally come to mediation, thankfully. I think that lawyer who'd written that letter was no longer on the scene. A slightly more sensible lawyer came along and said, yes, let's mediate this. And it was a very difficult situation. I think that the ashes had already been split by the time they'd come to mediation. One of the parties only found that out the day before the mediation, which was obviously a very difficult dynamic. It was really tough. But actually, it was a mediation where sort of halfway through the day, I decided that it would be helpful to actually get the individuals involved together without the lawyers present, just in a virtual room with me. And actually doing that, we managed to cut through years and years of complicated correspondence and hurt, and actually resolved it in about 10, 15 minutes. So it is amazing what can be done when the scene is set and where the right sort of tone is there and the right dynamics. It was, yeah, I mean, go back to what that lawyer said. I'm conscious that not everybody on this call is a lawyer. So just to briefly explain what mediation is, it's certainly not writing horrible letters for years. Basically, mediation is something that can happen to avoid court proceedings. It is where the mediator will work with the parties individually to listen to their perspective. And that can be done in the run-up to the mediation and then at the mediation itself, which tends to be a given day. And the party will work with the lawyer mediator will work with each party and try to understand their perspectives with a view to then explaining that perspective to the other party. Slowly but surely, the process does work. It's a tried and tested process, which is very successful. And it's a very flexible process. It can be done these days. It's regularly done online, which works very well for these types of cases where these families often really don't want to be in the same building as each other. That takes some of the intensity and anxiety out of the process. And it can be a situation where the parties are just kept in their own virtual or physical rooms all day, where the mediator shuttles between the two rooms. Sometimes you can get the parties together in the way that I just described. Rarely in these types of cases do you get everybody together in a full joint session, although sometimes that happens, but it seems to be going rather out of fashion. So it is a very flexible process. It's private, and these types of situations, ashes disputes, can be aired sort of and dealt with sensitively. So it is also something that can be accessed with or without lawyers. I do mediations. Most of the time there are lawyers involved, but very often I do cases where sort of one or both parties actually don't have lawyers either. And that actually is, obviously very cost effective and a very good way of resolving these types of cases. I had another case that didn't actually come to mediation. I had a phone call from a lawyer who said to me that she'd just had a call from somebody who was wanting to apply to court for an injunction. And it was to do with ashes. I think she was the daughter of the deceased, and she was in dispute with the deceased's partner. I sort of said, yes, I'd happy to try and help and see what I could do. And I spoke to this lady, and basically she was very angry, very upset, as is often the case. And I think she had been trying very hard to work out a way where she could get a proportion of these ashes at least, because there was a dispute about who had authority to actually instruct the funeral director. Nikki touched on that earlier, and I do think that is a big area where these disputes can arise, because people can be completely shut out. And if they're shut out and there is a dispute, then it can be very difficult to actually just have any kind of constructive dialogue. In this case, unfortunately, the funeral director had not handled the situation very sensitively at all. And I think that was what had caused part of the problem. They had suggested that this lady had a keepsake urn with the ashes, proportion of the ashes, but the way it had been presented to her and the context had just left this lady in a situation where she just felt like she was essentially being fobbed off with a little something that wasn't very special at all, and it just wasn't adequate for her. I made a couple of phone calls just to see what I could do to help. Spoke to the funeral director. He explained to me a bit more about this keepsake urn, and actually that it was a very beautiful urn, that it wasn't that small. And, I explored that with him. And then I phoned the lady back and just sort of explained that to her. And within seconds, she just said, oh, right, okay. So it's not, it's not that small. It's not, okay, and I can choose the urn, can I? And And actually then she just said, oh, it's just not worth it, is it? The day before, she had telephoned a lawyer wanting to go to court for an injunction. So I tell the story because it just shows that if these things are handled correctly and sensitively and carefully, and actually simply with the introduction of a neutral person who can just listen and just get a dialogue going, it can be resolved very, very simply. I mean, I didn't do anything magical on that day at all, just made a couple of phone calls to see if I could help, and it was resolved. So certainly sometimes if the tone and context is right and the dynamics are right, then often these disputes can fall away really quite easily. Sadly, they often do go off in completely the wrong direction and can just get incredibly sort of entrenched and difficult. So I think my sort of final message really around these types of cases is just sometimes they do need to go to court. Sometimes court is the answer, but it has to be, I think, the last resort. And if you do have to go to court, then choose your lawyers very wisely. Be very careful about who you instruct, because there are some lawyers out there who are a little bit like a bull in a china shop with these kind of cases, and there are many lawyers out there who are extremely careful and sensitive, who are used to dealing with these types of issues, and they deal with them very carefully. So I think it's always worth, as Nikki said, attempting to resolve these types of situations in a different way. And mediation is an excellent way of doing it. So I'm happy to answer any questions at any point around that, but I think that's everything that I've got to say.